Lord Bach.
My Lords, I beg to move that a humble address be presented to Her Majesty, praying that the Community Legal Service Funding Amendment Number 2 Order 2011, laid before the House on the 24th of August, be annulled, as set out on the marshalled, for the reasons as set out on the Marshall list. My Lords, in moving this motion, let me start by making it crystal clear that we on this side believe that there must be cuts to the legal aid budget. Over the last 30 years or so, until perhaps a few years ago, the amount spent on legal aid went up a great deal year on year. This was particularly true in the criminal legal aid field, until the amount spent on criminal legal aid compared to civil legal aid was totally out of kilter. As part of the necessary cuts, we, when in government, took action to reduce legal aid spending, and I don't apologise for it. Almost the last act we took in government, before the general election of 2010 was called, was to cut criminal legal aid advocates' fees in the higher courts over a 3-year period. It was not popular, but it was necessary. It gives the lie, by the way, to the present government's claim that we, the last government, were not prepared to tackle the deficit. If we had won that election, we would have cut further. My personal view is that there are, and this is a personal view, that there are large savings indeed to be made in our whole criminal justice system. And we had, in any event, published a white paper called Restructuring the Delivery of Criminal Defence Services that, if followed through, would have made considerable savings. However, my Lords, there are two considerable differences that exist between our potential proposals and those of the government. Firstly, Her Majesty's government are intent on cutting legal aid much too far and much too fast. They really have not given any, certainly not enough, thought to the consequences of their policies, either in human or in financial terms, which leads me on to my second point, that one of the areas in which they have chosen to axe legal aid and take it out of scope altogether and make savings in fees is precisely the wrong area of law. They intend to remove welfare benefits advice and representation at all levels, including up to the Supreme Court. Employment advice, much housing, even more debt, and some community care and education. In other words, my Lords, advice to the poor and to the vulnerable. They tend to save the sum of about £50 million per year for these cuts. Today, of course, we're not strictly debating the rights and wrongs of such an approach. We'll be able to do that in short order when the bill, currently in another place, comes to this House. Now, what we are debating tonight is an order that in one fell swoop cuts 10% from all, and I repeat all, civil fees, including family fees. To describe it as a rough and ready figure would be a gross understatement. It's a crude and unthought out measure with no evidential justification whatsoever. Even though I'm particularly concerned with the 10% cuts to social welfare, to community lawyers, the lowest paid, my Lords, of all the lawyers who do civil and family work. I want to acknowledge the powerful case put forward by other civil and family lawyers to me as a result of my motion being put down. I thank all those who have made their case, and there may well be champions for them tonight, although I know that because of the lateness of the hour, various noble lords whose contributions would have been very welcome on all sides have not been able to stay. Interestingly, though, there are really no comparable cuts on the criminal side, in, for example, the sister order that accompanies this particular statutory instrument. I would argue that this shows that the government is quite ruthless when it comes to civil and family legal aid, and as soft as butter when it comes to criminal legal aid. It's as though they have no sense at all of the fantastic value social welfare law has in our society, allowing at comparatively cheap cost many of those who couldn't possibly afford to get early legal advice, with the result that issues are solved, courts are not full of hopeless cases and litigants in person. And noble lords will perhaps have seen the concern of some justices of the Supreme Court in the newspapers this morning. For some reason, the government are determined to decimate social welfare law and drive out those hard-working, dedicated and poorly paid lawyers, I would argue, who practice in this field. My lords, who are these lawyers? They are often the not-for-profit sector. They work in law centres, citizens' advice bureaus and other advice centres. Some are solicitors and barristers in private practice. Many, wherever they come from, sacrifice more lucrative legal careers in order to practice this type of law. My lords, if they don't practice it, who will? When we what we refuse to do, forgive me, their fees are fixed fees brought in October 2007, raised by 2% in 2008, but untouched since then. They're not over-generous. We, as a government, brought in the fixed fee, and it undoubtedly caused problems in itself. We set up a study with many experts from this area of law to look into the problems and produced a document entitled Study of Legal Advice at Local Level in order to attempt to tackle those problems. What we as a government refused to do at any time, and particularly during the recession, was to cut legal aid spending on social welfare law. We increased it significantly from £151 million in 07-08 to £208.4 million in our last year, 9-10. We increased eligibility by 5%, bringing in 750,000 more people, and increased the number of new matter starts. And I'm proud of what we did. The proposed fees are set out, of course, in Table 1 of the order, to be found on page 4. These cases often take many hours' work. They involve face-to-face contact, and often the lawyer, having seen the client, has to speak to third parties in order to resolve the problem. They are by no stretch of the imagination well paid. There is an exceptional threshold, but a case has to be very long indeed and very complicated to come into that category. My lords, there are currently 52 law centres in England and Wales. They're not profit-making. They've had to make efficiency savings with the introduction of the fixed fee system. Many rely heavily for the excellent work that they do on legal aid. 8 generate over 70% of their income through legal aid contracts. None of these law centres has a 10% surplus, and they monitor cash flow on a weekly basis at present. There's no fat to them at all. All 8 are at risk of closure. 4 centres are particularly vulnerable, 2 in London, 2 outside the capital. £800,000 would immediately to be taken from law centres' funding overall by the 10% cut. In the medium term, of course, the combined effect of the 10% cut plus proposed scope cuts is that £8 million out of the £9 million in legal aid contracts that law centres enjoy will disappear. 8 million out of 9 million. of legal aid. 18 law centres out of 52 will just not be viable. It may be more. Where, I ask, my lords, will people go to in order to get their problems, their legal issues sorted out? My lords, I can make the same points about CABs, about Citizens Advice Bureaus, who have a very high reputation, as do law centres, in Parliament and outside. Obviously, CABs don't rely so heavily on legal aid, but many do, and at a time when local authority funding is frankly declining, CABs will also close as a consequence of this order. And noble lords will remember that a few months ago there was news, as it were, from Birmingham about the state of the CABs in Britain's second largest city. And private sector firms that do this work, they work on the same legal aid rates. All day long, my lords, I have been receiving emails from solicitors that do this work. Sometimes, of course, other parts of these firms subsidise the social welfare law part of a firm. But I've been told, in fact it will make an extremely interesting database, the amount of money that legal aid lawyers of many, many years standing get per year. It's much, much less, of course, than that of a solicitor who does not do that work and compares extremely badly with other professionals. Very badly indeed. My lords, those who practice in this field, who do this sort of absolutely invaluable work, don't expect enormous rewards, but nor do they expect to be penalised even further. My lords, let me end, if I may, with the story of Law for All. Law for All was in West London. Many noble lords may have heard of it. It was quite a large organisation that provided legal help in the fields of debt, employment, family law, housing and welfare benefits. They also provided representation for many people over many years. However, my lords, they have now been forced to close down in anticipation of the reduction in the fixed fee and, of course, the fact that 90% of their work is being taken out of scope in the bill that is currently going through Parliament. This is a tragedy for local people who received legal help in 1,500 cases last year. The local authority in that part of West London is generous, but the government's proposals have meant that Law for All has closed its doors. I have this afternoon spoken to the Chief Executive, or should I say ex-Chief Executive, who confirmed that the 10% cut that we are debating tonight and the taking out of scope had driven them to close. My lords, because of course, it's important just to point out that even where the area of social welfare law is not to be taken out of scope altogether, such as in some housing cases, for example, and in some debt cases connected with housing cases, the order that we're debating tonight means that the continuing work, for example in housing, will be reduced by 10%. All housing work that stays in scope will be affected. My lords, how much will this save, you may want to know? The whole order, including the 10% cut in civil and family legal aid across the board, is worth £45 million, it's estimated, saving. The cuts as they affect social welfare law fees is all of £5 million. That's a figure that the Legal Action Group have confirmed. Of course it's a rough figure, but it shows you just how much, or rather how little, will be saved by this order. Saving £5 million in fees, when Her Majesty's Government intends to spend, what is it, £250 million on ensuring that their weekly rather than fortnightly collections of rubbish. My Lords, it's absolute nonsense. Haven't we got our priorities entirely wrong? In today's Hansard, the noble Lord the Minister has answered a question that I asked him at column 137, with the information that in cash terms, spending on legal aid in the last year, 10-11, was some £66 million below provision. And yet the aim is to save £5 million by cutting these fees by 10%. My Lords, I'm not allowed to seek to amend this order, and I therefore have to pray against it as a whole. Whether I vote against it tonight will depend, of course, on what other noble lords say in the course of the debate that I hope will follow, and of course particularly on what the noble Lord the Minister says. My Lords, I beg to move.
The question is that this motion be agreed to.